All right, what's up, everybody? It is time to talk about individual liberties. This is a massive lecture. There's a lot of stuff to get through. You probably noticed that when you read through the book. So let's take a look at some stuff today. We're going to be talking about individual liberties, or civil liberties as they are known. Civil liberties are protections from the government. So stuff that the government cannot do to you. You need to be able to differentiate between a civil liberty and a civil right. Those are different things. A civil liberty is a restriction on government that makes it so you can do whatever you want without interference from them. Civil rights are protections where the government actively tries to make sure that you get your rights to, like, life, liberty, property, things like that. So, moving forward, we're going to be talking about civil liberties for right now. These are mostly in the first couple of amendments in your Bill of Rights. Except for three. Three is stupid. I mean, great. What are you talking about? It's the best. So, where most of our individual liberties are in amendments 1 through 6. So let's talk about them. We've talked about the First Amendment protections already, but we're going to go through each of those in more detail. But remember FRAPS, F-R-A-P-P-S, FRAPS, the freedoms of religion, assembly, press, petition, and speech. These are the 5 freedoms in the First Amendment. This lecture will be up on the Moodle page. So if you really want to see a fantastic, cringy video from like 2004, 2005, then you could see me playing World of Warcraft before you were alive. So great video from me. Here's a little preview. Oh, wow. It's a parody of another video where druids can do... Oh, God. All right. One of the things that we talk about when we're talking about individual liberties is the balance between liberty, how much we're able to do, and safety, because those are kind of on opposite ends of a spectrum. People always bring up this Ben Franklin quote. It's taken wildly out of context and isn't actually what he's talking about here. But he still has a pretty good point. So the quotes, those who would give up potential liberty to purchase a little temporary safety deserve neither liberty nor safety. So the idea is you can either be completely free from any kind of control, or you can have some semblance of control and have that safety, and individual liberties are that balancing act between those things. If we have absolute freedom, then horrifying things could happen. People could just start, killing each other, even though, that seems to be happening already anyway. But absolute safety is no freedom at all. So, got to do this balancing act. There's a couple of things that affect each of the liberties that we're going to be talking about. One of the biggest things is public interest, how much people give a crap about it. So you'll find that if people give not that much of a crap about it, then it's not going to be very high on the government's list to do things. Like whenever you see Supreme Court cases, you have to have someone make a case in the legal system for it to even get to the Supreme Court. So there's a whole bunch of stuff that isn't even talked about because it's not a matter of public interest. Then you have the matter of a compelling government interest. You're going to hear that phrase a lot, probably. But whenever the government has a compelling interest in doing something, it's probably going to do it. So, for example, one of the things that we're going to talk about is your safety as public school students. The government has a compelling interest to keep you safe, so they will impose more restrictions on you as public school students. We also have restrictions called time, place, and manner restrictions. prior restraint, and clear and present danger restrictions. So that's all stuff that we'll go about in more detail in a bit. So let's go through the First Amendment and talk about some important stuff. The first part of the First Amendment is the religion part. There are two parts of the religion part of the First Amendment. Two clauses that are very important to know. The Establishment Clause and the Free Exercise Clause. The Establishment Clause states that the government is not able to establish an official religion. So the state can't say, hey, welcome to America, you have to be a Protestant Christian in order to be here. Like, that's our official state religion, is Protestant Christianity. They're not able to do that, and government employees are not allowed to compel people to do that. That's why me, as a teacher, I'm not able to preach to you. Proselytize is a hard word to say, apparently. So we can't establish an official religion. We can't compel people to join a specific religion. But also there's the Free Exercise Clause, which, within reason, allows people to worship however they want. They can worship whatever they want as long as it does not infringe upon the rights of other citizens. So, for example, if you're really into like ancient Aztec blood sacrifices, you can practice that religion as long as you don't murder people for blood sacrifices. That's not okay, given that murder is illegal. But a lot of different things, when it comes to religion, are totally fine. Rastafarians and the Hmong religions use ritualistic animal sacrifice as part of their worship practices. So that's something that they're able to do. So, oh no, is my face in the way? My face is in the way. Should I move it up here? I'll move it up here. Where face? I don't know where my face goes. Who cares? Right up here. This is the flying spaghetti monster, who is the deity of the Pastafarians. It's a very interesting group of folks. I would recommend reading about them. Now, let's talk about some court cases. The first one I want to talk about is called Engel versus Vitale. Engel versus Vitale was a prayer in the schools case. So what happened was New York had like this official time for people to have a non-denominational prayer of some kind. The teachers of the school were required to recite it. Students didn't have to, but they did have to stand for it. They could leave the room if they really, really wanted to. But a bunch of families said, hey, non-denominational prayer is in and of itself prayer. So you're forcing students to pray to something at times, and you guys are the government. So that's a violation of the Establishment Clause. So he sued, well, a group of 10 people sued the old government. I use this as a mnemonic device. This is the industrial metal band Rammstein. My favorite song of theirs is called Engel, which means angel. But Engel is also the claimant in the case. So, fun thing to remember. They're also, Rammstein's very, very weird. So, that's why you're probably freaked out looking at them. Here's the majority opinion, 7-1 in favor of Engel. Since public schools are government institutions and students are compelled to go to it, then that would be, the government has a compelling interest to not, proselytize to them. So even though students, it was non-denominational, God, as a general term, is not non-denominational. And there are lots of students who are, atheist or agnostic or something else. Or some people are polytheistic. So there's a ton of exceptions to that you can't use. So even though they gave you the option to leave a lot of students feel peer pressure. They might feel ostracized if they leave the class to be able to get up and say, hey, I'm not going to do this prayer thing. So that, for a long time, was the standard, where you couldn't have a school-sponsored prayer. That has since changed, but let's examine some ways that the free exercise clause applies to things. That's Weird Al in Amish Paradise, which is a fantastic song by Weird Al. The other court case we're going to talk about is Wisconsin versus Yoder. This is a free exercise case rather than an establishment clause case. So in Wisconsin in 1972, there was a statute that forced students under 16 years of age to attend school. If you know anything about the Amish, they don't give a crap about the stuff that you learn in school, in late high school. They're going to raise barns and do farming and weave blankets and do heating and stuff. They're very technologically impaired. So that's not stuff that the Amish society is into. So the Amish said, hey, this statute is kind of silly for us because the stuff that you teach is not something that we will use as Amish folk. And we want the ability to take our children out of school at the 8th grade, because that's when they're going to start, building barns and stuff. So they wanted to focus on trade skills instead. And the Supreme Court absolutely agreed. 7-0 in favor of Yoder. The state's compelling interest in compulsory education didn't outweigh the Amish's interest in what they were doing. So they said, hey, they're getting an education within their community, so it's absolutely okay for people to take their kids out of school at the 8th grade so they can learn how to do Amish stuff. Over there on the right, that's some Amish stuff. I wholeheartedly recommend listening to Amish Paradise by Weird Al. It's good stuff. Hitching up the buggy, churning lots of butter, raise a barn on Monday, soon I'll raise a nutter. Think you're really righteous? Think you're pure at heart? Well, I know I'm a million times as humble as thou art. I'm the pious guy the little omelets want to be like, on my knees day and night, scoring points for the afterlife. So don't be vain and don't be whiny, or else my brother or I might have to get medieval on your hiney. I'm in silence in my house, so it feels really weird to do that. So, how this has changed. We kind of had to get some nuance in it, and we like to do these legal tests to try and determine whether or not things are okay or not. So, after Engel versus Vitale, we had a test to determine how to best balance religious entanglement in public institutions. And the court case that determined that was Lemon versus Kurtzman. So it's a 3-pronged legal test. Well, it was anyway. We'll learn more about that in a second. And it asks 3 questions. Legal tests just ask simple questions and then have a criteria for failing. So the questions it asked are, does the policy have a secular purpose? That means a non-religious, just educational, flat purpose. If no, then it fails the Lemon test and it isn't allowed. Does the policy have an effect that neither advances nor prohibits religion? So you can't proselytize for a religion or stop people from worshiping a religion. If it does either of those things, it fails the Lemon test. And does the policy create a relationship between the government and religion where their internal affairs are entangled? If that happens at all, then it's a failure on the Lemon test. So, this has very recently changed. We had a court case called Kennedy versus the Bremerton School District in 2022 that definitely overturned Lemon versus Kurtzman. kind of overturned Engel versus Vitali. This high school football coach was really, really psyched on this Christian football film where the coach goes to the 50-yard line and prays, and so he just started doing that because he saw it in a movie. And he works for the school. He is a school employee and started praying on the 50-yard line. And it started getting popular with players and other people on the field. The school board was really, really worried about getting sued because they're like, hey, this is a government employee, and if students start feeling pressured to pray with this guy on the 50-yard line, that's going to constitute excessive entanglement in religion. So they told him to stop, and he said no. So he kept doing it, and it kept getting more popular among the community. And so the school board suspended him. They're like, hey, we're not going to try and mess with this because this is a lawsuit waiting to happen. And then that in and of itself was a lawsuit waiting to happen. So Kennedy sued and won 6-3 in favor of Kennedy. The court determined that even though he is a public school official, his prayer spectacle was not disruptive. It was personal speech protected by the Free Exercise Clause and not stopped by the Establishment Clause. So they have now abandoned the Lemon Test in favor of what they call a history-based approach to ruling, which wasn't really explained too well. I can't remember who wrote the opinion for that. I think it was Sam Alito. Don't quote me on that, though. So let's move from religion to speech. We're going to talk about Schenck versus the United States. 1919. Who knows what we were doing in 1919? For those of you who just shouted World War I at your computer monitor, good job. Those of you who did not, also good job. I don't know. So during World War I, we had a draft to get people to join the military so we could win World War I. So a lot of people were not very psyched on that draft, including one Charles Schenck, who was a socialist, who started distributing pamphlets saying, hey, you should not participate in the draft. You should tear up your draft cards and say, hey, you don't have to serve the government. The 13th Amendment protects you from involuntary servitude. And he got arrested and charged under the Sedition and Espionage Acts. So they said that he was committing espionage by stopping people from participating in the draft. Schenck, argued that he has the right to free speech, and so he was able to do that. He's wrong. Very wrong. Big wrong. 9-0 in favor of the United States. Schenck was creating what we call a clear and present danger to the country. By stopping people from getting drafted, he was putting the country at risk since we were at war. So because there was a clear and present danger, that speech was able to be limited. You always hear the example of shouting falsely, claiming there's a fire in a crowded theater. That would be considered a clear and present danger. Now, please note that we do not use this anymore as our litmus test for limiting speech. But it was the beginning of our limitations on speech. And so we study it anyway. I didn't know how to get something memorable for Schenck versus the United States, so I put beef shanks up there. Schenck sounds like shank. Beautiful. So, clear and present danger. Speech can be limited if it incites unlawful or dangerous activity. So, you can say, hey, I don't like the Social Security Act, but you can't say, hey, let's blow up that building and protest against the Social Security Office or the Social Security Act. So, you're able to talk about not liking Social Security, but you can't incite violence against it. We also have these restrictions called time, place, and manner restrictions. Your speech has to be at the right time. in the right place, and it has to be the right manner of speaking. The restrictions that are on speech have to be content neutral. You can't ban some speech but not others. Asterisk on that. We'll talk about that in a second. The restriction needs to serve a significant government interest, so it'll be things like protecting people from harm, or making sure traffic runs okay, or making sure students in school are learning instead of distracted, things like that. It has to be narrowly tailored, so the restriction has to be super precise, and you must be able to express yourself in different ways, ones that aren't violent. Like, if you're trying to protest outside of a doctor's house at 2 a.m., that's not the right time, place, or manner to do so. You have an alternative way to protest, which is not doing it at 2 a.m. You could do it someplace else and stop violating noise ordinances and things like that. Schenck has since been overturned, and we use a new test to determine whether or not speech can be limited. Clear and present danger is not enough. Instead, we use the Brandenburg test. Brandenburg versus Ohio was a court case. Kind of awkward background on Brandenburg versus Ohio. Brandenburg is a member of the Ku Klux Klan, and the Ku Klux Klan wanted to hold a rally in Ohio, and their local government did not want that to happen, given that the Ku Klux Klan is known for doing racial violence, and that's not good. So Ohio argued, hey, the Ku Klux Klan is known for violence, so we're going to stop them from having this rally or march because it's likely that violence is going to happen. And the Supreme Court determined that just because it's hate speech doesn't mean that it's automatically going to be violent, so they instituted this new test about imminent lawless action. So there's a two-prong test for the Brandenburg test. Is the speech directed to inciting or producing imminent lawless action? So is the speech actually directing people to do violence? And is the speech likely to produce that action? If the answer to both is yes, then the speech can be limited. And the intent of the speaker matters. One of the reasons that Donald Trump was impeached after the January 6th incident was because they were wondering if his speech incited imminent lawless action when he said, we're going to fight like hell, and then people charged the Capitol and did a bunch of violence. Was that him directing people to do that? Did he intend for that to happen? Was it likely that that was going to happen? So those were all the questions that the court was considering when talking about the old insurrection. Let's talk about you guys for a minute. The truth of the matter is you have way fewer rights than adults do. Don't let anybody say that you have the same rights that adults do when you are going to public school, because that is just a lie. That's not true at all. But there is hope yet, because in 1969 we had this case called Tinker versus Des Moines. In 1969, you might remember that we were embroiled in this war called the Vietnam War, and it was not a very popular war, given that we went to war based on the government just lying to our faces. And it wasn't very popular at all. So there was a draft and sending people to go kill kids when, there wasn't really any reason to do so. So that was fun. And a lot of students got really involved in activism and protesting against the war. Mary Beth Tinker was one of those people. They were really not psyched on the Vietnam War, and so they wanted to protest at school. What they did was wear black armbands. You can see the armbands there with a peace symbol on it. So during school, they wore those armbands to show their distaste for the war. School administrators found out and said, hey, please remove the armbands because we don't want to cause a disruption at the school. And the students said, no. And they got suspended, and then they sued the school. And thankfully, the Supreme Court decided in favor of Tinker. She's still alive. That's her right there, signing black armbands. And the famous quote is that it can hardly be argued that either students or teachers shed their constitutional right to freedom of speech or expression at the schoolhouse gate. Big asterisk by that, but that was Justice Abe Fortas saying that just because you're students at a school doesn't mean you don't have the right to free speech. Now, take that with a grain of salt, but in this particular case, there wasn't really a disruption of the learning environment because students were just wearing armbands. It's armbands like normal. It wasn't like yelling. There wasn't a loudspeaker. There weren't like loud marches or anything. And if it's non-disruptive symbolic speech, then it's totally fine. That said, you do have severely limited rights. Because of my favorite court case, Morse versus Frederick, that I affectionately call the Bong Hits for Jesus case. So, some students in Alaska were going to a school-sponsored trip to watch, I think it was to watch the Olympic torch run through their city, or a parade or something like that. But it was a school-sponsored trip to the parade, and some very, very smart students decided that it would be a great idea to hold up a massive banner that said Bong Hits for Jesus. This was back when marijuana was not legal in most states, and was a very, very big no-no to talk about, especially in conjunction with a religious figure. So administrators suspended the students, saying, hey, you disrupted the school-sponsored event, and you shouldn't be encouraging people to do illegal drugs. And they said, hey, we have the freedom of speech. And they sued the school and lost a lot. So you were very, very much restricted in what you can say at school. Just look at dress codes or anything. Like if you wore a shirt to school that said Ganesh loves cocaine, we would probably not allow you to wear that. Ganesh is a Hindu god. He's the big elephant. So, fun. Obscenity is a weird one. So, a lot of people have different ideas of what constitutes something that's obscene. I'm sure we have different ideas of what that means. And it's a notoriously difficult thing to define. Obscene speech is not protected speech. And the guideline used to be this line from Justice Potter, which was, I know it when I see it. He was referring to a movie that people had called pornographic, and he said, I know it when I see it, and this isn't pornographic. So, like, for years, the standard for whether or not something was obscene is if a judge said, yeah, that's obscene. We have since created a legal test for that. It's called the Miller test. We have to determine whether or not the content is bad enough to be considered obscene, and it's a pretty strict test. And it has some fun words in it. So the first question is, would the average person applying contemporary community standards find that the speech appeals to the prurient interest? So prurient is just like gross sexual stuff, like weird stuff when it comes to fornicating. Does the work depict or describe in a patently offensive way sexual conduct or excretory functions specifically defined by applicable state law? Yuck. And does the work taken as a whole lack serious literary, artistic, political, or scientific values? So a lot of times people will show really gross things for an intended political statement. Like people who protest outside women's clinics who are against abortion might show some gnarly pictures of aborted fetuses. And while some people might find that obscene, it does not lack serious political value to show that kind of imagery to those things. So even that kind of really, really disturbing imagery is not considered obscene. It has to be straight up gross porn and poop stuff that has no artistic value whatsoever. So, obscenity. But make sure you know that silly quote by Justice Potter. I knows it when I sees it. It's silly. Let's get to the press. One of the terms you're going to need to know is prior restraint. Prior restraint is the idea that the government can step in and stop a publication from actually sending out the news before it's published if it is harmful to the government. And there are a couple of different court cases that we talk about this with. The most recent one, and I think the one that matters the most, is New York Times versus the United States, where after the Vietnam War, the New York Times had access to these Pentagon papers that detailed the United States' completely flawed reasoning for going into the Vietnam War. And they were like, we're going to publish this to show that the government was incredibly wrong in their reasoning for us going to Vietnam. The government said, hey, that would be really, really damaging to us, and we don't want you revealing like state secrets like that, and so you're not going to publish that. And the Supreme Court supported the New York Times and said, hey, unless there's like super potential for danger, the government can't use prior restraint to stop people from publishing stuff. There's another one that your book likes to talk about called BARRON versus Baltimore that says the opposite, that prior restraint is totally reasonable. That one took place a long time ago, and the New York Times versus the United States is the update to that. So you'll need to know both of those. The right to assembly. The big key word there is peaceable assembly. You have the right to peaceably assemble. There's a lot of laws that are controversial because they get the peaceable part either wrong or they have different ideas of what constitutes peaceable. So, like, is it peaceable assembly if homeless people are just congregating in an area? Or what if ladies of the night are on a corner? Are they allowed to stay there even though they're soliciting, crime? What if there's a bunch of members of a known gang just sitting around the place? Are they peaceably assemble or are they there to do some violence? What constitutes an unruly protest? There's a whole lot of grumpy rhetoric going back and forth during the 2020 Black Lives Matter protests. A lot of people said that the protesters were violent or rioting, and there was confusion over who incited that violence or started the rioting. What evidence was there that it was going to turn violent before stuff like tear gas and pepper spray were thrown around? And another question to take into consideration is the public disruption. Are people blocking the roads? One of the reasons why the Occupy Wall Street protests were largely unsuccessful is because they tried to occupy like actual streets, and the government cracks down on that pretty instantly. And if you want to block a street, you have to get like proper permission to do so because you're stopping the city from like working. You don't want to stop the roads. Don't block the roads. It's a bad idea. Unless you have a permit, then go ahead. That's a good time. You don't need to know any of these cases. I tried to find some Supreme Court precedent that talked about peaceable assembly, but these are some cases that were brought before the Supreme Court. The one that I think is kind of funny was Coates versus Cincinnati. So they made a statute that 3 or more people couldn't just like be loud or annoying in a place, and the Supreme Court was just like, yeah, no, being annoying is fine. Like, There's no law. You can't make a law against being annoying. That's dumb. So, and there's those as well. Not too much case law on the right to petition. You can ask the government to fix stuff. Yeah. Go to public things and say, hey, government, change. And they might say yes. Moms for Liberty is a far-right group that really, really likes using this this right to this individual liberty to advocate for banning books in schools. So that's fun. Watch some of those school board meetings sometime to have some entertainment? Question mark? All right. That was just the First Amendment. We're 35 minutes in, and that was the First Amendment. There's a bunch more. So, let's talk about due process, because one of the things that keeps coming up when we're talking about these individual liberties is infringing upon due process of law or not providing due process of law. So we need to kind of figure out what due process is, because that is confusing. So, due process is, well, it depends on which type of due process you're talking about. There's two types, one that's easy and one that's hard. Let's talk about the easy one. It's called procedural due process. Procedural due process is just the steps the government has to take to do stuff. So, for example, if you've ever seen like Law and Order, they will arrest someone. What do they do when they arrest someone? They read them their Miranda warning. You have the right to remain silent. Anything that you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand this as I've read it to you? Like, they have to do that. And then they go to booking. They have an arraignment. They actually have a trial by jury. Like, that step-by-step process is something that they have to do. And that is due process. So you're not able to deprive someone of life, liberty, or property without going through that process. You can deprive them of life, liberty, or property. You just have to go through that process first. The second one is called substantive due process, and that one is kind of amorphous, and it's in danger. So basically, it's whether or not the substance of a law violates an individual's right to life, liberty, or property, whether or not, like, the soul of it. So that one's really murky. We'll talk about some ways that it historically has come up and some stuff that is recently happening. Hey, we just talked about this. So pretend you're getting arrested. What happens? So you have to go through the process of things. Like, in order to even do anything to you, cops have to have either reasonable suspicion or probable cause. Reasonable suspicion, they need to have an idea that crime is occurring. There has to be something that's happening that would suggest that crime is happening. So reasonable suspicion would be if we were in the classroom and I smelled weed, I could be like, hey, someone in this classroom is smoking weed. And that would give me grounds to search folks. Probable cause is there's actual evidence of wrongdoing being occurred. Wrongdoing being occurred? Occurring. There we go. So if there's evidence of something happening, then the police can act on that. They have to tell you what you're being charged with and bring you before a judge. That's called the writ of habeas corpus. You can't deny habeas corpus to people unless you're Abraham Lincoln. They have to read you your Miranda warning to tell you what your Fifth and Sixth Amendment rights are. You have to have a fair trial. If they don't do any of that stuff, then there's this rule called the exclusionary rule. So if they don't read you your Miranda rights, any evidence that they obtain after that has to do with your Miranda warning. So if they don't read you your Miranda warning and in the car ride over, you're like, I murdered 46 people. Here are their names and their addresses. They cannot use that evidence to secure a murder conviction. Now, they might use other evidence to secure a murder conviction, but not that evidence. It can't be admitted to court. There's a court case that's really important that talks about that. It's called Mapp versus Ohio. MAPP versus Ohio. That establishes the exclusionary rule. That is a Street Fighter 4 flowchart for Ken. I don't think anybody in this class plays fighting games, so that probably won't be funny to you. But if it is, let me know. Selective incorporation. I don't know. Selective incorporation is weird. The 14th Amendment, because of its due process clause, does this thing where it takes our individual liberties and applies them to states. Before we had selective incorporation, the Bill of Rights was just considered national law. Like free speech, the right to bear arms and all that stuff, that was not something that states had to uphold. So once we had the 14th Amendment, we get the 14th Amendment's due process clause, we start integrating those individual liberties to the states as well. We have a couple of different rights that are still not incorporated, but we could talk about some that are. In fact, I think your discussion forum is to talk about that, so that's good. I couldn't think of anything for selective incorporation except for making pasta. That's someone slowly incorporating flour into the egg mixture to make pasta. So if you've ever made homemade pasta, you know what I'm talking about. Yeah. Guns! Hopefully everybody knows that I personally bring 2 guns with me every day I come to school because I got this one right here and I got this one right here. Woo! I'm incredible. Saying the cringy jokes while I'm alone in my office at night, it has a very different effect than when I'm actually talking to you in class. So, there was a court case called the District of Columbia, Washington, D.C., versus Heller, where Washington, D.C. Passed a handgun ban. They said, hey, no one can own handguns. And people in Washington, D.C. got very mad and sued and won. So that handgun ban was struck down as unconstitutional. And then later, Chicago passed kind of a similar gun ban. And that also went to the Supreme Court and got shot down. Shot down because guns. Because they said that the District of Columbia versus Heller should have been selectively incorporated to state governments. So D.C. versus Heller established that you can't have a handgun ban at the federal level, and then McDonald versus Chicago selectively incorporates the Second Amendment to make sure that states can't do that as well. If you ever hear about someone being like, oh, Chicago's the most dangerous thing that has the strictest gun laws in the country, that's just not at all true. It's not a thing that exists. They've tried to do that and have not been successful in doing so. So it's not super difficult to get guns in Chicago. Also, I thought it was funny that that's Ronald McDonald and he has a gun and it's McDonald versus Chicago. Yeah. All right, moving to the Fourth Amendment now. The Fourth Amendment protects you from unlawful searches and seizure. The police cannot search you or your stuff if they don't have a warrant or probable cause. There needs to be something like immediately that they can tell where a crime is happening. Something within plain sight. There's what we call a plain sight rule. So like if you're pulled over at a traffic stop and in the back seat of your car, there's like some brass knuckles. You're not supposed to have brass knuckles. The police officer can say, hey, I see brass knuckles in your back seat. That gives me probable cause to search your car. Otherwise, if they don't have probable cause, no, they can't search your car. Don't let them search your car. That's a bad idea. Unless you're at school, in which case I can have reasonable suspicion and just search all of you. I'm not going to do that, but that is something that is possible. The fella in the car there is known as a sovereign citizen. If you want to see some people that are really cool and fun, I recommend looking up sovereign citizens. It usually ends in their windows being broken. We already kind of talked a little bit about probable cause versus reasonable suspicion, but probable cause is heavier. You need to have actual evidence that something bad is happening, that crime is afoot. Reasonable suspicion is less concrete than that, but it also doesn't allow for as stringent of searches. Like if a cop has reasonable suspicion that a crime is occurring, they might be able to detain you to ask you questions about something, but they can't like indefinitely stop you. They can't search you. They can't arrest you unless like they find something that gives them probable cause to do that. So the distinction between those two is pretty important. I don't know why I was so psyched on stabbing when I made this. There's a bunch of stabbing stuff. New Jersey versus TLO is a court case that established my ability to search you guys at school if I have reasonable suspicion because of weed. There's some weird stuff about cell phones where like information on cell phones isn't readily accessible and isn't probable cause unless it's like an immediate threat. So that's kind of weird. When canine units get involved, you have to make sure that you have a warrant to actually use the dog before you do things at all. You can't just like bring a dog around and be like, where are the drugs at? Good dog, find all the drugs. There has to be an actual like reason or suspected crime for you to bring the dogs out. Some weird modern examples with the Fourth Amendment on phone stuff. The government just looks at your metadata. Period. There was this fella named Edward Snowden who worked for the NSA, the National Security Agency, and saw that we had this massive surveillance apparatus called PRISM that just collects all cell phone metadata from everybody in the club getting tips. And so the government just kind of has access to that. So you're under constant surveillance and nobody seemed to care. So Edward Snowden just lives in Russia now. He's like, bye, I had to run away because I thought that I would tell people about this and no one cared. Several years ago, there was a mass shooting in San Bernardino, and the government kept asking Apple to unlock the shooting suspect's iPhones on terror charges, and Apple refused to do that because they didn't have their ability to unlock the phone would set a weird precedent for like companies working with the government to invade people's privacy. So there's a whole big thing with that. Eventually the government got into their phones and discovered some stuff, but it's a very odd and murky situation when it deals with people's private information. You'd think that because they're suspects in a crime and there's reasonable or there's probable cause that they did, terrorism, that you could search it, but who knows? All right. Next is the Fifth Amendment. This is protections for those who are accused of crimes. These are your Fifth Amendment protections right here. You can't be held for a capital crime. A capital crime is one that kills you, where the death penalty is on the table. You can't be held for a capital crime without an indictment by a grand jury. A grand jury is a group of people that examine the evidence before they go to trial to see if there's enough evidence to even hold a trial. So if there's like crap for evidence, a grand jury will just be like, no, why would we do that? It's just a waste of time to do that. So you need to have a grand jury if there's a capital case to look at the evidence and say, yeah, there's enough evidence to go to trial here. There's protection against double jeopardy. Double jeopardy is being charged with the same crime twice, the exact same crime twice. So if you commit burglary and then you get out of jail and then commit a different burglary, you can still go to jail for burglary again. It's just you can't be tried for that initial burglary twice. It also sets up eminent domain, which is the ability of the government to take your stuff as long as they give you just compensation. This was a big deal when the Interstate Highway Act was going up, where the government bought a lot of people's homes and just demolished them, just built highways through lots of black neighborhoods, usually, to build interstate highways, to build suburbs, to connect urban areas to suburban areas. So that was cool. This is a weird exception that I don't think we really need to know about. There's a public safety exception to the exclusionary rule that's wildly specific. If you're questioning a suspect before reading the Miranda warning and the questioning is for the purpose of neutralizing a dangerous situation and a suspect responds, this is, why do I even put this in here? This is a very, very specific case. Read through it. I like the Pop-Tart example. That's good stuff. Also, I used to like the show Sherlock until I realized that it wasn't very good. Sixth Amendment, more protections for people accused of a crime. You have the right to a speedy and public trial. Speedy is, you got to take that with a massive grain of salt, because speedy doesn't really have a concrete definition, but you can't just hold people in jail indefinitely, like we were doing to people in Guantanamo Bay. You also have the right to an impartial jury in a criminal case. You can't just have people who are biased against, they'll interview people to make sure that the jury selection is good. You have the right to be informed of the crime being committed or what crime you're accused of. So that's part of the writ of habeas corpus, being able to see a judge for a specific crime. You have the right to see witnesses, the people who are witnesses against you, and you have the right to call your own witnesses. It would really, really suck if you could only have witnesses against you. That would be awful. And you have the right to a lawyer. These are folks that were protesting the denial of habeas corpus to prisoners that were held in Guantanamo Bay. I think your book talks about Hamby versus Rumsfeld in 2004. Fun court case. There's a movie about this court case, and if you have the patience to watch this, then you could probably watch the movie too, because the movie's much more entertaining than this lecture is. But Gideon versus Wainwright. There's this fella named Clarence Earl Gideon who was accused of breaking and entering into a pool hall in Florida. He was not given a court-appointed lawyer and tried to defend himself. He did so very, very, very poorly because he doesn't know how to be a lawyer. He didn't go to law school and doesn't know how to do anything about calling witnesses or cross-examining witnesses or nothing like that. So while he was sitting in prison, he filled out what we call an in forma pauperis brief, which means in the form of a pauper, where he said, hey, I wasn't given a court-appointed lawyer, and I feel like I probably should have been given that. And the court said, yeah, you should have been given a court-appointed lawyer. It used to be that it was only for capital cases where a right to counsel was guaranteed, but they said, no, any criminal case, you have the right to counsel. Always get a lawyer. Always. Because right after that, Clarence Earl Gideon got a court-appointed lawyer. That lawyer went and fought for him and easily won the case that he tried to defend himself. The movie's called Gideon's Trumpet. Really good movie. I suggest checking it out. The 7th and 8th Amendments. The 7th Amendment doesn't really matter too much. It's the right to a jury trial for civil cases. I mean, that's nice, but it's not something that we talk about too much. The Eighth Amendment is controversial, not because of excessive fines or bail, but because of the cruel and unusual punishment clause in it. This is where a lot of people have the argument over whether or not the death penalty is okay, because depending on who you ask, the death penalty is cruel and unusual punishment. It used to be that hanging was cruel and unusual punishment, and then there's a lot of people that argue that lethal injection is actually cruel and unusual punishment. So there's a whole gaggle of arguments about it. Half of the states in the Union have the death penalty, half of them don't. Oklahoma and Texas use it more than any other state. They use it a whole lot. All right, here's where we get to substantive due process. Substantive due process means that the substance of a law can't deprive people of life, liberty, and property. The law is unconstitutional if the substance of it inherently denies that stuff. The biggest substantive due process right that we have is the right to privacy. Nowhere in the Constitution does it say that we have the right to privacy. The Fourth Amendment protects us against unreasonable search and seizure. That does not say that we have the right to privacy. But there are several court cases that have suggested that we have a substantive right to privacy. All of them, well, one of them has already been overturned, but all of them are currently being, well, not currently, but the Supreme Court wants to consider them for overturning. One of the first ones that we're talking about is Griswold versus Connecticut, where they said that they prohibited contraception. So any kind of contraception for non-procreative sex was disallowed. And the court said, no, you can't disallow contraception just because people are having sex and you don't like it. So they said there's a reasonable expectation of privacy when you're doing stuff like that, and you have a reasonable expectation to be able to buy contraception without the government interfering. It was the same thing with Roe versus Wade. Roe versus Wade, a very, very well-known case. You've probably heard of that one. Here's the facts of the case. A lady named Jane Roe sought an abortion in Texas after getting pregnant at 19. So she challenged an anti-abortion statute in Texas. The ACLU sued, and the Supreme Court agreed. They said that people have a substantive due process right to privacy, and that the decision to get an abortion is between women and their doctors, not the government. So it basically allowed abortion on a national scale, but said, hey, this is not something that we need to have public. So they have the right to privacy about their own bodies, and their choices about abortions are their business with their doctors and not ours. There's some more stuff about that. A lot of this doesn't really matter anymore because Roe versus Wade has been overturned. Roe versus Wade got overturned by a court case called Dobbs versus Jackson Women's Health Organization in 2022. Mississippi passed an anti-abortion law called the Gestational Age Act, banning nearly every type of abortion until after 15 weeks. Jackson's Women's Health Organization sued, saying that they haven't provided evidence that their law protected the viability of the fetus is its ability to live outside the womb. And before 15 weeks, that's not the case. So there's a whole lot of nuance with fetus viability that was considered. But they went all the way to the Supreme Court, and the Supreme Court decided to overturn Roe versus Wade and devolve the right to decide abortion law to the states. Oh yeah, here's that. One of the big things to come out of this is that the Supreme Court has said that one member of the Supreme Court in particular, Clarence Thomas, my favorite of everybody on the Supreme Court, Clarence Thomas said that we need to revisit every case where the substantive right to privacy was considered. There are 3 that are really well known that he wants to take a look at. The first being same-sex marriage from Obergefell versus Hodges. We've already talked about Obergefell versus Hodges in this class. The right to contraception case that we just talked about, Griswold versus Connecticut. And there's another one called Lawrence versus Texas. That's the right to have consensual adult sex with whomever that you want for non-procreative purposes. Basically, there was a statute banning gay people from having sex, and that was determined to be unconstitutional based on the substantive right to privacy. Clarence Thomas wants to revisit and overturn those 3 cases. Sometimes individual liberties get curtailed when it comes to national security. We had this incident called Pearl Harbor, where the Japanese attacked us, and our government, in their infinite wisdom, decided that anyone of Japanese descent at all should go into a concentration camp. So every Japanese American, whether or not they had allegiance, like they were citizens of Japan, most of them were what we call Nisei, second generation Americans. Like their parents came over and started a life in America. They were all American. So we just put Japanese Americans into concentration camps. So that was fun. There's a fella in those camps named Korematsu who sued the government, saying, hey, this is a clear violation of my due process rights. And the Supreme Court said, nope, just go ahead. Go ahead and do that. Go ahead and do the concentration camps. So we've had some issues with people who are suspected terrorists and where jurisdiction gets murky with those. Like, if they're a suspected terrorist, do they get tried as U.S. citizens in U.S. federal court? Do they go to a military tribunal, a special court? Or we've also had cases concerning torture where people were denied their rights as accused people, and they were like force-fed and tortured while they were in custody in Guantanamo Bay. There was lots of waterboarding, force feeding, fun stuff. So that's Donald Rumsfeld. He was a big fan of torture, and that picture is very scary. So that is all our stuff on civil liberties. So there's some more stuff in your book. Always make sure that you defer to the book for your information on things like that. Those court cases are going to be pretty important, all the ones that we talked about here. So try and check out them court cases, and I'll talk to you in class. Have a wonderful day. Enjoy refreshing time. Mr. Ryan, out. Click.